All right. Welcome, everybody, to our Take Action San Diego monthly meeting on Zoom. And my name is Wendy Galernter. I'll be your host today. If you have any technical difficulties, we have Help Desk Larry, as usual, on the call. So just contact him in the chat if you have any questions. And I want to get right into the program because we have a lot to cover today. And most importantly, first, please say hi in the chat and let us know where you're calling in from. I know most people here are from San Diego or different parts of San Diego County, but we always have some people from elsewhere around the country. Um, we do have a guest speaker who I'll talk about in a minute, and we will have a Q&A section for her. So when you do have your many questions, please try to put them in the Q&A rather than the chat. It's a little bit easier for us to find them there, but we will find them no matter what. So really appreciate all the questions and information people post. And then finally, the only other thing I want to say about that is that everything we talk about today, including the video for today, as well as any of the links that we mentioned, will be sent to all of you in an email within the next 24 hours, so you don't have to scribble stuff down if you don't want to. On to our agenda. Our guest speaker today is Madiba Dennie. I will tell you a little bit more about her in a second, but suffice it to say, we're incredibly lucky and honored to have such a wonderful speaker here, and I know you're going to love what she has to say. After her talk, after we finish with the questions and answers, we'll talk a little bit, because how could we not, about No Kings and what it meant to some of us. And then, as usual, we'll go over some upcoming actions and events that we want to make you aware of. But let me tell you a little bit about Madiba, who's here today as our guest speaker. She is an attorney, a columnist, and a professor, and her work focuses on fostering an equitable, multiracial democracy. I first became aware of her when I went to a screening of a documentary called How to Save Democracy, which we'll send you the link of. This screening took place in a small city in upstate New York called Glens Falls, well under 100,000 people in this city. And over 200 people showed up to see this movie. And in the movie, there are about 10 thinkers and activists interviewed on how to save democracy. And Madiba was one of the people interviewed. And what she said was so interesting and so insightful and so provocative that soon after I saw the movie, I contacted her, taking a chance because I really didn't think we would be so lucky. But she got right back to me, and she is here today to speak to us. You may be familiar with her already if you read the Atlantic magazine or the Washington Post. She's published there frequently. If you watch the BBC or MSNBC, or if you read her legal commentary in her newsletter, Balls and Strikes, among many other forums. Or you may know about her book, The Originalism Trap, How Extremists Stole the Constitution and How We the People Can Take It Back. And that's going to be the main subject of her talk for us today. So without further ado, I give you Madiba Dennie. And thank you, Madiba, so much for being here.
Thank you for inviting me and for that very kind introduction. It's a pleasure to be here. I'm glad to have a chance to chat with you all. Like Wendy said, I'm author of The Originalism Trap, and I want to hit on a few of the big themes in the book in the time that we do have together. So I figured we can talk a bit about what originalism is, why it's terrible, and what we can and should be doing instead. So, originalism is the idea that the meaning of the Constitution is fixed in time, that it's frozen at the moment of enactment. Like when the Constitution was ratified, that's how its provisions were just locked in. So if you ask an originalist how you should interpret the Constitution today, they would say there's only one way you can legitimately interpret it, the way it was interpreted 200 years ago. And this used to be a fringe idea, but over the past few decades, conservatives made it the dominant method of constitutional interpretation. And the Supreme Court is now stacked with people who embrace the originalist ideology, and the country is suffering the consequences. So I'm going to give you an example of what originalism looks like in practice. And it's one of the examples that really pushed me to write this book, and that's the Dobbs decision. So Dobbs, as we all know, 2 years ago, 3 years ago, goodness, ever since 2020, I've completely lost all sense of time, but that's a separate conversation. Dobbs was the decision that rescinded the constitutional right to abortion. First time that's ever been done. And while I knew that it was coming, I feel like I was aware of its imminence from the moment that RBG died, and I was like, oh, this is about to get real bad. But it still hit different seeing it in writing, and seeing the conservative supermajority's explanation as for why. Uh, so Justice Alito's opinion in Dawes basically says I don't see enough historical evidence that people had a right to decide when and whether they should give birth in the 1800s. So they don't have that right now. Uh, Mind you, so one that's not even the only exclusive historical record. Like he just sort of picked out his favorite bits because there's actually a bunch of historians submitted a amicus brief in the case saying, well, it's not even quite right to even think of it as an abortion because like they didn't even consider abortion as a thing that happens until you can even feel the kick. So it's just like everything about the framing was wrong, but none of that actually matters. Samuel Alito was not really interested in the details and how what it looked like in those women's lives and what it could look like in our lives today. All of that was irrelevant. He was just actually using it as a basis to say there were no rights in the past, so there are no rights in the present. Surely this is what the framers wanted. So I thought this was transparently anti-intellectual, anti-woman, among other things, and yeah, just found it infuriating. So originalists they pretend, as Alito does here, that there is a single objective discoverable meaning of the Constitution, and that we can be certain what it means today if we just look at the right old-timey dictionary or their favorite historical anecdote. And any historian would tell you it's not that simple. But even if we could, I think that does not mean we should. Much of the country was much worse off then, and originalism deliberately doesn't account for the progress we've made or how we may need to adapt fundamental principles to ever evolving needs and understandings about society. So that is the sort of center of why this all matters. I know that the idea of constitutional interpretation can seem a little abstract or lofty, but it really has practical effects. It shapes and constrains our rights and our ability to vindicate them. It affects our access to power and our efforts to build a just society. And so the predictable, and I would argue often desired consequence of basing constitutional interpretation on makeshift historical standards is the endangerment of historically marginalized people. I think that by its own terms, originalism is essentially make the Constitution great again. And the court is just using originalism to return the country to an inequitable version of the past. I will say this, though, as I think about how conservatives have used originalism to upset what people may have thought was solid legal ground, and see really just since Trump re-entered office, all of the catastrophes that he has inflicted and that the Supreme Court has indulged. So, looking at the administration's actions and the judiciary's entertaining of some of those actions, I think it underscores that the constitutional order is in a state of flux, and that the ever shifting landscape of legal interpretation has serious, tangible effects on our lives. In cases like Dobbs, obviously that's awful. And, seeing the sort of suspicion with which some originalist judges are looking at birthright citizenship, even, again, awful. But flux in and of itself is not awful, I think. Uh, all of that awfulness, though, inherently shows that legal change, even rapid and dramatic legal change, is possible. It provides us with incontrovertible proof that we do not have to live like this. None of this is set in stone. And anyone telling you that this is just how things are is wrong. I think people on the left in particular are often told to aim lower, to wait longer, to be more realistic. Well, the reality is that we can decide for ourselves what constitutes legitimate legal thought. And this is something we've seen occur, not just with the court now, but we've seen this happen over time in great ways as well. Like we've seen public agitation, people in the streets, much in the way that we all were in the streets for No Kings, coming out and demanding shifts in how people think about the law, and that has actual effects. One of my sort of favorite examples to give about how this occurs is, there was not actually any change within like the four corners of the page of the Constitution between the Supreme Court saying that you can make it like a crime to like riding a train car while black, to saying that segregated schools were unconstitutional. Nothing actually changed in there except for how people demanded the Constitution be interpreted. So that's the first thing that I think I really want us to take a hold of, that originalism is bad and we don't need to hold on to it. There's nothing sort of intrinsically correct about it. We can be thinking about how to shape the law differently so that it serves us. And I think that this is even not just what I want as, a lefty person, but I think it is firmly grounded in the Constitution as well, by way of the Reconstruction Amendments. The Reconstruction Amendments are those amendments that were added to the Constitution in the wake of the Civil War and just changed the entire document because it was the first time that the federal government constitutionalized rights for people of color. They expanded the political process, deliberately set out to build a multiracial democratic society for the first time. We have gotten away from that. And I think that's what we need to get back to. Not that moment in time, like they still had a lot to learn when they ratified the Reconstruction Amendments, as much as I love them. But those principles and that liberatory mission of making this democratic society that we can all live as equals, and as political equals and be able to engage in society, that's right there in the Constitution. So actually, I should specify, since maybe not everyone just has in their heads what those amendments are. So I should take a beat and say what they are. I got a little carried away. So the 13th Amendment is what constitutionalized the prohibition on slavery, with one unfortunate exception for people who are convicted of crimes. The 14th Amendment is very broad. There's so much in there telling you about equal protection, due process of law, and giving the federal government the power to legislate, to pass new laws to effectuate that goal as well. And the 15th Amendment works in a similar way in that it guarantees the right to vote free from racial discrimination and gives the federal government the power to pass legislation to implement that. So we see in the Reconstruction Amendments that it is the government's responsibility to build this functioning multiracial democracy, to sort of ensure these like egalitarian principles. And my theory, I like to call this inclusive constitutionalism. I think that the Constitution includes everyone. That's what the Reconstruction Amendments tell us, and that we should be interpreting any part of the Constitution, in order to build that inclusive democracy. So when we look at any sort of section, we should be looking at it through the lens of the Reconstruction Amendments, saying these aren't just something that was tacked on as a nice little addendum. It's something that transformed the entire rest of the document. Like you need to look at everything that came before it differently, not just the slaveholders version, but the abolitionist version, the freedom version. That's what we should be thinking about. Um, so stepping away from the originalist idea of interpretation has to be based on a point in time and looking instead at point of principle. And that principle is liberation. That principle is, freedom and like an egalitarian society that works for all of us, not just the, rich white guy conservatives, not just them, but for the rest of us too. So that's sort of the grand theory of the book. And so I explain in the course of the book just like ways that we've seen originalism occur, how it got to be so popular among the judiciary, and how we might go about developing this new inclusive constitutionalist jurisprudence instead, and in doing so, build this democracy. I think, I don't want to go on for too much. I think that was probably around 15 or so minutes. Did I get that right? Okay, good. All righty. Well, I'll stop there so I can make sure I get some questions.
Okay, thank you. That was amazing, Madiba. And I see we have a comment or a question from Mark. Um, I'm going to read it and we'll see where it goes. The originalists on the court have shown in many cases that the term simply means they've assumed the right to interpret the Constitution in any manner they choose. But this is a double-edged sword. With the rise of the unitary executive, they're about to confront the reality of authoritarian and illegal usage of presidential power at the expense of the other two branches, including their own. In other words, the court may shortly be put in the position of either saving or condemning the document. Your thoughts on
Yeah,
that?
yeah. I mean, I think that's pretty astute. I think that originalists pretend that they're being more objective by having this strict historical standard. But as Mark is saying, they are just interpreting it however they like. And they do this by, picking their favorite parts of history and ignoring all the others. Or they like zoom in at like, like a really small level of generality. This is one of the examples I give in the book, when some of the conservative justices a few decades ago were writing against LGBTQ equality. They were like, well, I looked in the Constitution and I looked in history and I don't see anything about like a right to sodomy. And it's like, okay, obviously there's nothing about a right to sodomy, okay? But how about like a right to dignity and personal autonomy and privacy? Like these are things that you would find like some record of. But so it just really just depended on like, how they wanted to look for it because of what they wanted to find. So I think that is correct, that it is really just a sham. Uh, and we can instead, instead of them sort of like hiding the ball in order to get to this terrible result, we can sort of be upfront and say, the whole purpose of the Constitution is making this democracy, so that's how I'm interpreting it.
Cool. Okay. And so we have two related questions, one from Cecily. So what do we do? And about originalism, and Caleb sort of following up with how can ordinary people advance the idea of inclusive constitutionalism, specifically those of us outside the legal profession?
Yeah, those are excellent questions. So for folks outside the legal profession in particular, um, there's a lot of room for creativity. Um, like I think that so one of my favorite examples is like the Montgomery bus boycott. I think it's impossible to understand the Supreme Court saying that like segregation is unconstitutional beyond in schools without taking into account uh, how the people in Montgomery had been basically declaring, no, no, we know this is wrong. Like we know this is unconstitutional, and basically forcing the court to catch up. So like boycotts are one option. Other forms of protest. The court has not yet recognized that like a strike is like a constitutionally protected protest. And I believe it was some teachers in Virginia went on strike anyway, even though there was like a law saying that like public school employees could not go on strike. And they said, well, it's our right. Like we have freedom of speech. And I would personally add, you have the freedom to not do forced labor under the Reconstruction Amendments. So that means you get to stop working and negotiate the conditions of your labor. And so again, they're just sort of declaring how they viewed the Constitution and sort of like forcing people to catch up. And so I kind of think that something that normal, everyday people can do, like regardless of whether they're a lawyer, is just sort of like think about, what is going on in your own life? Like what is like this issue like affecting you? And can think there about like how your constitutional rights might fit in, so that you can invoke that right, even if the court doesn't recognize it yet, so that people start to recognize it. Like basically asserting that the right exists. Because honestly, that's what I mean. That's happened a lot over time. But B, I'm thinking about the Second Amendment as like a pretty glaring example. The individual right to a handgun, that was not formalized as a constitutional right until 2008. It was not a thing. Even some Republican justices were mad about it at the time because they're like, y'all are just making stuff up. And like they were kind of indignant about it. They're like, this is just, like pulling the wool over people's eyes. But the NRA and like the sort of like gun lobby, like constituency, fought for it, claimed that the Second Amendment protected their individual right, and basically got enough people on board, and got enough powerful people on board too. So I think basically you can kind of fake it till you make it, and just sort of like popularize your idea of what you think the law should be, and sort of manifest that.
Well, and here's one with a much shorter timeline attached. This is from Sherry, and this is how do we persuade SCOTUS to not further gut the Voting Rights Act?
Oof. Okay. That is a very hard question. I honestly don't know if that's possible, to persuade this Supreme Court to not further gut the Voting Rights Act. Listening to those oral arguments the other day in the Calais case, it did not sound good. To me, it sounded like they had already made their minds up and they were just sort of batting around trying to find what they thought the best rationale to put down on paper was, but they knew what they were going to do. So I think there are I don't know if we can persuade them to not further gut the Voting Rights Act, but I think there are a couple of things we can do. One is, trying to stop the bleeding, trying to like minimize the like, even if we're going to lose some, trying to like minimize what we lose. Like try like give the court like an alternative way of, okay, you don't have to strike down Section 2 entirely. You can just take away like this one particular remedy under Section 2. And that's like a sort of like a lawyerly like strategy thing, but I think that's one potential way that to try and minimize that harm. But real thing that's got to happen is reforming the court. I think that, that will be important because these guys on the court are really just political actors with robes, and they just get to go to work in their pajamas instead of in suits like the Congress people across the street. But they're doing the same thing, just like furthering the goals of the conservative legal movement. And I think that they'll just continue to do that unless forced not to. So I think that court reform is going to be important, and the sooner the better.
What does court reform entail, in your opinion?
I think it can and should entail a lot. So one of the things is court expansion. Once Trump is out of office, obviously. I don't need him putting any more justices on the court. But I think that that is one of the fastest ways and also the most clearly constitutional way to deal with like our current situation. The size of the court has changed throughout history. Sometimes it's gotten bigger, sometimes it's gotten smaller. So I think that that is something that's clear cut, no issues. You can put more justices on the court, and put some people out there who act right. And it will prevent us from being in a situation where we're trying to enact some like new other reforms, and this Supreme Court just strikes it all down. So I think that's step one. Step two as well is term limits. I think that one is a little trickier as a legal matter, I think. There are ways you can do it, but it's just less clear cut than the court expansion, because of a provision in the Constitution that says that that federal judges get to serve while they're in good behavior, and good behavior has been interpreted as life tenure. I think that was maybe a mistake. Like these people are not behaving well. Like that would, yeah, one of my little hot takes is what if we defined good behavior by statute? Um, but yeah, so there are ways though of potentially dealing with it by like say, okay, we're not kicking you out of the federal judiciary, but we're moving you to like a senior status, where you're basically like a reserve justice. So if there is if enough people recuse that now like the court can't decide a case, then I guess maybe you can come out. Or I guess we can like send you around to a lower court or something, as opposed to just letting you continue to make Supreme Court decisions continuously for the rest of your natural life. But that's not where court reform ends. I think there are a bunch of possible options. One, again, sort of, what's the word I'm looking for? Controversial, and a sort of spicy one is the idea of jurisdiction stripping. So Congress actually decides what kind of cases the federal courts hear. So, they could tomorrow be like, actually, we're passing this law to say the court is no longer deciding these constitutional cases. We can make a new constitutional court that only decides the constitutional issues, and y'all can decide something else. So like that could be one thing. I think there are also, court reform could include sort of just other ways of pressuring the justices. Some of my favorite ideas are ones that just sort of like just would get on their nerves. But I think we shouldn't undervalue the effect, the possible impact of being annoying. Just like saying, if you make it too uncomfortable for them to continue in this course of action, that can influence behavior. Um, and so some ideas I've heard in that regard, one is making the justices ride circuit again. This is an old-timey tradition. If they care about history so much, we can bring back circuit riding, which was where justices would literally ride horses and to various circuit courts, like the appellate courts below the Supreme Court, and sit in judging those cases. And honestly, I find that idea hilarious. And something else I find really funny, and again, it's a historical throwback. The Supreme Court didn't always have such like a nice, fancy, luxurious building. They used to hear cases in the basement of the Capitol, and so I'm like, put them back in there, or put them in a broom closet. Uh, or I'm like, cut their budget for AC in the summer in DC. Or like cut their budget for clerks and make them have to do their own work. So basically, I think there's like a lot of options of things that people can do, and we should feel free to just think big. Like don't constrain ourselves to just term limits or just court expansion. I think we should look at our sort of like full range of possible options.
I, one of the things I appreciated in the movie that I first saw you in was your sense of humor. So appreciate some of those suggestions, including a few questions here about impeachment and if that's an option or a feasible option.
Yeah, I mean, this Congress not gonna go for it. Like we've seen that, but like in general, absolutely. It's like the things that make them the things the justices have done or have failed to do that currently warrant impeachment will still be true then. So I definitely think that a Democratic majority Congress could and should pursue impeachment. I think that about some of the lower court justices as well, like Emile Bove. Like he should have never been confirmed, and so as soon as Democrats get Congress back, they could kick him out. So yes, I agree with that being a necessary step. And yes, that actual real ethics enforcement that falls, I think, under the umbrella of court reform for me, and is another necessary thing because yikes.
Yes. Excuse me. So this one is, if you have about 5 more minutes,
Yeah,
can
of
we keep
course.
going? Okay,
Mhm.
great. This one's from Marie. The current court seems to give great deference to the executive branch. How do they frame that view from an originalist perspective when the
Mm.
Constitution was written, when we were declaring our independence from kings?
Right?
How might how might we call that out when conversing with others about this?
Yeah, okay. Yeah, I think that is can make a very plain statement about that when you're seeing the court give the president so much authority. Say, isn't that what they fought a revolution against? They're trying to concentrate power in one individual. And that is, like what the whole like basically, if you go through the Declaration of Independence, a lot of the grievances that are being listed against King George are literally things that Trump is doing now. It's kind of shocking just like how similar they are. So I think you can tell people like, hey, these guys are lying. These guys are making stuff up. Like they said that they're doing this because history, but history actually says the opposite. I feel like that is, something you can like say to folks to just say, hey, these dudes are not telling the truth. They are lying about their sources. Like you can crack open any book and see that this is the exact opposite of what the framers were actually going for. Like they would not recognize this government. They would be horrified by this government. And yeah, they basically like make up this idea. I think I saw someone mention in either question or comment earlier this like unitary executive theory, basically saying, oh well, if we're to have a functioning like an energetic president, they need to be able to make all sorts of unilateral decisions, and they need to be able to fire anybody whenever they feel like it, and that's just completely ahistorical. They're just making that up out of whole cloth. And so, yeah, I think there is some value to saying they just made that up because they want to help their president. You know, saying like that's not actually grounded in anything other than their shared goals or their shared, party registration.
Yeah. Okay. Two more questions. This one's from Peter. According to Justice Jackson, the court's playing Calvin ball, meaning they're making up the rules as they go along. How will this Calvin ball from the top court impact the legal profession as a whole, perhaps
Mm,
undermining the entire basis of law as following precedent?
yeah. I think that is a very real concern and something that lawyers are struggling with and that even judges are struggling with. Like lower court judges don't know what to do with the court's rulings if the court is, flipping a coin on whether or not it's going to follow precedent. If a lower court follows precedent exactly, and then the Supreme Court just issues a no opinion like explanationless order, just one sentence saying like this opinion is stayed. Uh, the lower court judge has no idea what to do with that. They're like, well, I see that they're saying I was wrong and that I shouldn't have done that, but they didn't say what part of it was wrong or like what I should be doing instead. So yeah, I think it is really, what's the sort of word I'm sort of looking for? Um, because undermining, I guess it's a way to put it, that it sort of diminishes the integrity of the institution. And to that extent, it's horrible, but I think, to that extent, maybe it's an avenue to be able to push for court reform, to push harder, saying like, hey, clearly these guys are just doing whatever they want. Like this is not working. So we need to be, thinking more seriously about like how the court is structured, who's on the court, like what they have the authority to do, how they and how they should do it, as in terms of like what their, method of interpretation is. Um, so yeah, I think it is rough out here to be for lawyers and for people who have to live under this shifting state of law. But I think that makes it all the more important for us to say what we think the law should be and to fight for that in our communities, in our lower courts, in state courts. Most cases go through state courts rather than federal courts to take every opportunity we can to start putting forward this affirmative vision. Not just saying they're wrong, but saying here's what would be right.
And two final questions, maybe short answers on each. Um, One is with some of the reforms you're proposing, Deirdre's asking, which she agreed with all of them, but how do we avoid it appearing tit for tat? Like you screwed us, so now we're going to screw you. And
Yeah.
and the second one is, what do we do if the next election is clearly rigged?
Oof. Okay.
From
Let's see.
Sess.
For the first question about what do we do about appearing tit for tat, I think one is roll your eyes and to say like it does not no does not matter. Like part of me is okay with that. Like they can think what they want. But I think the more mature part of me thinks we look at again the sort of goal, as I was saying, the purpose of the Reconstruction Amendments, saying like this isn't about you, it's about all of us, and it's about like what kind of country we have the right to live in, and making sure that we all get like equal enforcement of our rights, and we have to change how things work in order to do that because. Because the court or some of the people in your party lost sight of that. So yeah, it's not like just that you're on punishment. It's that we're trying to make something real that works for everyone. Um, as for the second question, that's a much harder question. What we do if the election is clearly rigged? Okay, let me think for a second. here's what here's what I would do. I think if it like was clearly rigged, that the rightful winner should just continue to act as if they did win. That they should just have a sort of competing shadow government. Like they want to talk about deep state. Well, like here's your deep state. We'll straight up have this like competing institution. Just like appoint your cabinet, like declare like what your positions are, and just sort of call their bluff, I think.
Yeah, and that's where, because we have talked a few times in this group about a general strike, that would probably be the time
That
to
would
get that
probably be the
rolling
time.
too.
Yeah.
Yes. Well, we got to almost all of the questions, not all of them, but you did us such great service with all the information you gave, everything that's getting us thinking. And of course, if people have more questions, they can buy your book. And we have the link to the book in the chat. And it will also be in the email that we send to people in the next in the next 24 hours or so. So I wanted to thank you so much for your scholarship, for your time, for your hopeful, cheerful approach, even though these are very dark subjects that we're talking about, and somehow holding both of those at the same time, I think
Yeah.
is important.
I'll close with that because I think that as it's very helpful for me to remember that there have always been people who fought in dark times. There have always been people who saw that light or forced everyone else to see that light. And if everyone was still, if people still found it in them to fight in those conditions, then we can do this too.
Thank you so much. And that was a great way to close. Good luck with all your work, and thank you for being part of today.
Thank you so much.